Officer Dave, would you open the courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning.
Good morning.
Morning, Ms. Strickarts.
Good morning, Judge. How are you today?
I'm good. How are you?
I'm just fine, thank you.
You have Jefferson Capital versus Destiny Smith.
Yes, Your Honor.
I had her a moment ago and she went away. So I put you in the way.
Okay, thank you, Judge.
Mr. Neal,
Good morning, Your Honor.
what file brings you here today?
Here for security versus Jones. Last three is 393.
Okay. Let's.
Should be an objection to garnishment.
Okay. I have a number of people who are here by names that I don't know, so I have to get back to you. But I'll
Sounds
put you
good.
back. Counsel,
Good morning, Your Honor. Melissa Moore.
what file are you here on?
I am here on Travis Foster versus the Huntington National Bank, and I'm here for Huntington, the defendant.
Oh, okay, so you are my pretrial.
Correct.
Okay. I'm gonna probably do most of my objections to Garn first, so I'll put you back in the waiting room.
Okay, thank you, Your Honor. Is the other side here, might I ask?
I don't know.
Okay,
Not identified by such. I have a couple people as telephone numbers, so I can't tell you.
sure.
All right, back to the waiting room. All right, let's see who this is. Hello,
Hello,
what is your name?
Destiny Smith.
All right, hang on for just a second. I have Ms. Strickhart's here. We're ready to go. This is file number 1816390, Jefferson Capital System versus Destiny Smith. Date and time for objection to garnishment. Your appearances.
Good morning, Your Honor. May it please the court, Suzanne Strickhartz, P 44018, on behalf of the plaintiff.
And what is your name, ma'am?
Destiny Smith.
You are the moving party. What is the basis of your objection to garnishment?
The amount is wrong.
What does that mean? The amount is wrong.
Oh, I'm sorry. Well, I never incurred the debt in the first place for it to be any debt. But when I called, it states, well, they stated that it was $1,572.64. But on the wage writ, it states that it is $1,759.40.
Do you have any other basis for your objection to garnishment?
That the garnishment would cause a hardship for me, and I'm still trying to figure everything out. Like, I have proof that it's not even my debt.
All
It's
right.
somebody I was staying with.
Anything else you want to tell the court?
No, sir.
Ms. Rickards?
Yes, Your Honor, we did file a responsive pleading, Judge, where we attach the accounting on this debt to show that the amounts are correct and proper. It's a 3-page accounting. I don't know if the defendant had an opportunity to review it, but it does show that the amount garnishment was correct, and the amounts owing are in accord.
Okay. Anything else, Ms. Smith?
No, sir.
The court's had an opportunity to review both the objection to garnishment and the written response with attachment filed on behalf of Ms. Rickards. Court finds you have failed to state a valid objection to garnishment for the reason that the amount still due and owing is accurate as reflected in that itemized bill. In regard to your claim that this is a bill that belongs to someone else, Michigan Court Rule 3.101K specifically provides you may not use the objection to garnishment as a method of attacking the validity of the underlying judgment. Having failed to state objection to garnishment, that objection to garnishment don't have to be denied. You have an absolute right not to appeal my decision. That appeal must be perfected in 21 days of today. Finally, I will point out to you that while financial hardship is something you all recognize as human beings, it is not a valid basis for an objection to garnishment. Thank you all for coming in. We are off the record.
Thank you, Judge.
That all you got,
Thank
Mr.
you.
Cox? Thank you.
That's all I have, Your Honor. The order will just be mailed out.
Yes, I'll mail it out today.
Okay, thank you so much, Judge. Have a good day.
Be safe. Hello? 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 What is your name? There we go. Hello?
Yes, hello. Good morning. Can you hear me now, sir?
Yes, what is your name?
My name is Carso Jones.
All
I'm
right,
the
hold on.
defendant.
Hold on, I have Mr. Neal. We are on the record calling 2-1-155-393 Security Credit Union versus Carso Jones. Date and time for objection to garnishment. Your appearances.
Good morning, Your Honor. Wesley on behalf of Security Credit Union P number 80307.
Your name, ma'am?
Defendant Carso Jones.
You are the moving party. What is the basis of your objection to garnishment?
The amount that they say I owe is incorrect. I provided paperwork with my objection letter. court forms to show that the amount is incorrect. So when I signed up with credit union to refinance my car, I had to take on their gap insurance. The gap insurance, as you see on, Exhibit 3, was the $3,460 that was added to my total cost of the $19,637. When I was off on medical for 6 months, I was not able to make my car note. So I did surrender my car in. Once they put the car up for sale, I was not aware of anything. But when I received a letter in the mail showing what they sold the car for and what all was subtracted from the amount that was owed, they failed to show the subtraction for the $3,460. So they wind up saying that I owe $8,181.84. But when me and the attorney was going to court, he kept saying that I owe 7,000. I'm sorry, I'm trying to get to where they say I owe 7,000. He was trying to say that I owe $7,238.42. But even once I went back to work in February, because my doctor passed away, so I had to find another therapist when I could come off to work. You see, my receipts, which is Exhibit 2, I was making a $200 payment, as they asked me to do. The representative of Security Credit Union asked me, when I go back to work, will I be able to make the $200 payment? So I told them I was not for sure. But when I went back to work and I got my second check, I started making payments, as you see as the receipts. But on the first receipt of the first receipt for February the 22nd, 2021, you will see they say the previous balance was $7,238. Then they say new balance, $7,038.42. But then when I made my payments, at the second page, the last time before they served me my court papers, they say I only owe $6,138.42. Well, with that $6,138.42, if you subtract the $3,460, it will wind up saying that I only owe $2,678.42.
Mr. Neal, your response.
Just very quickly, Your Honor, we did not receive this motion until last night, hence we did not file a written response to it. But having reviewed the file since yesterday afternoon, I can say, for one, this judgment was entered by a motion for summary disposition. The court did review the file, it checked our numbers, and granted a judgment based on the amount that we sought, with enough sufficient evidence to validate that. The defendant, based on the motion, or the objection we received, said they received the writ from my bank. They did attach documentation stating questions regarding the balance and documentation regarding payments made on the account. However, based on MCR 3.101K, the basis for objection cannot be used to attack the underlying validity of the judgment, which basically sounds like what the defendant is trying to do here. The court has already reviewed the balance that was entered in for the judgment, the documentation submitted. We have documentation to support the balance that the court has entered on this judgment previously. I'd be happy to supply any additional balances or answer any additional questions the defendant has on that. But we stand by the balance that was received. We don't see any deficiencies in the garnishment itself, nor any reason the court should reopen the judgment itself and take a look at why it was entered or what the balancing is. For those reasons, I do think the court should deny this motion.
Ms. Jones, is there anything else you want to tell the court?
Yes, as far as the objection to the garnishment, I did check off F, and I checked off number 2 that was up under F, and I gave 2 copies to the court. And I told the court, the lady that was working behind the window, one was for the judge and one was for the attorney. so that can be mailed out to the attorney.
All right, let's stop.
So
right there.
she took it and she said, okay, that they will mail it out to the attorney.
All right. Court's
And
prepared.
that was on the day that this was submitted on 7/20/25. I'm sorry, on 7/25. I'm sorry. Yeah, 7/25. So I did get 2 copies, one for the judge and one for them to have mailed out to the attorney.
Well, he says that he received it, he said he got it yesterday. All right.
Yes, I do apologize.
The court's prepared to rule on this matter. The court entered judgment in this matter by summary disposition on April 1st, 2022. Total judgment in the amount of $8,208.03, including damages in the amount of $6,948.81, costs of $154.22, $11.05 for attorney fees. So that amount is concluded. Michigan Court Rule 3.101K specifically provides you may not use the objection to garnishment as a means of attacking the underlying judgment. Having failed to state a valid objection to garnishment, that objection must be denied. Ma'am, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. The court will send out to both of you an order denying the objection to garnishment. Thank you both for coming in. We are off the record.
Thank you, Your Honor. Appreciate it. You have a good morning.
Thank you. You too. We are on the record calling file number 21153-057, Jefferson Capital System versus Anthony Bryant. Date and time for objection to garnishment. Your appearance, sir.
Yes,
Tell me who you are.
Anthony David Bryant, Your Honor.
Sergeant, we were together last week on this matter, correct?
Yes, Your Honor.
And my recollection is you testified under oath at that time that you've been in the military for at least 18, 19 years.
Yes, going on 25 right now.
Going on 25. Thank you again, sir, for your service. I'm looking at the SCRA that was submitted with the judgment in this matter. It indicated, and this is dated August 18th, 2021, that that individual was not on active duty status, had no start date, not subject to recall. Obviously, we have the wrong Anthony Bryant. This matter was scheduled for hearing today at 10 o'clock. Like last week, attorney for the plaintiff has failed to appear. We obviously have the wrong Anthony Bryant here. I granted your objection to garnishment last week. This is the objection to garnishment related to the Navy Federal Credit Union. Sir, your objection to garnishment will be granted again. We'll send out your order again and again. Thank you, sir, for your service.
Thank you, Your Honor. I have a question, Your Honor.
Sir,
Is there some forms that I could file for a countersuit for pain and suffering and defamation of character? Because I get in a lot of trouble when I have to tell my chain of command that I can't pay my bills.
okay, I can't give you legal advice. So what I would suggest you do is you check with a military attorney.
Okay.
I can't give legal advice to either side in litigation.
All right.
Okay.
Thank you, Your Honor.
Let's be safe out there.
All right. Take care. You have a wonderful day.
You too, sir. We're off the record. Mr. Jamal,
Yes, good morning, Your Honor.
let's call your file. This is file number 21149-632, Citibank versus Terrence Mickens. This matter is scheduled for hearing today at 10 o'clock on the objection to garnishment. This is an adjourned date. We were adjourned from July 27th to today's date. And now we have a time, and then we've had an attorney appear on behalf of the plaintiff, but the defendant at 10:26 has not appeared. Sir, your appearance?
Yes, good morning, Your Honor. Joseph Jamal on behalf of the plaintiff, Citibank, P71254.
Yeah, Mr. Jamal, have you had any additional pleadings from the other side?
We have not. We've had some communication with the defendant, but no actual pleadings received by this office.
Okay, well, I'm going to proceed. He has failed to appear. In his written objection to garnishment, I have never lived at the residence address where documents were mailed to. Well, there are two problems with that. The first problem is that this is an attack on the validity of the underlying judgment, which is not permissible under MCR 3.101K, and that really is dispositive in the motion. But just to flesh out the record, I would note for the record that the court permitted alternate service in this matter on Mr. Mickens in an address on Pingree Street in Detroit. We have a postal verification dated 3/15/21 indicate that mail was delivered to Mr. Mickens at that address. In addition to the first class and certified mailings, the court also had posted by a 36th District Court officer copy of the summons and complaint in order for alternate service. So I'm going to find that Mr. Mickens, who has failed to appear, has failed to state a valid objection to garnishment. The objection to garnishment will therefore be denied. Sir, I will send out to you a copy of the order denying the objection to garnishment, noting that Mr. Mickens failed to appear.
Yes, thank you, Judge. I do have one question. Did the defendant include any additional documentation with his objection since we did not receive a copy of that? Or is it just the objection itself?
I got the objection itself, and there was an identity theft report dated 3/5/20, reported to an Officer Atkins, apparently in Southfield, saying that he had a address. There had been some identity theft. However, he said he became aware of this in March of 2020, and the office location is in a state other than Michigan. So I don't know what validity that, if any, that has.
Okay, well, I appreciate that information. We'll probably reach out to the court to get a copy of that, just so we've got it for our records.
Okay, good enough. Thank you.
Thank you,
Be
Judge.
safe.
You as well.
We're off the record. We are on the record calling file number 222422826, Travis Foster versus Huntington Bank Shares. This matter was initially commenced by the filing of a complaint in Small Claims Division in the 36th District Court. The matter was thereafter, removed to the General Civil Division. This matter is scheduled for pretrial today, August 10th at 10 o'clock. It's now 10:32. Could I have your appearance, please?
Good morning, Your Honor. Melissa Moore appearing on behalf of defendant Huntington Bank.
All right. I do not have an appearance from the plaintiff in this matter, excuse me. There is, and I should make this record clear, there is someone who has been in my waiting room described as S. Nash. I do not have a Nash on my docket this morning. I have attempted to admit that individual on at least 3 separate occasions, and they never seem to come in. So the defendant has failed to appear. Excuse me, the plaintiff has failed to appear. The defendant is Ms. Moore. I'm going to dismiss this matter without prejudice.
Thank you, Your Honor.
Send you out of order today, counsel. Thank you.
Thank you. So just to clarify, the court will prepare the order.
Yes, I'll be scribbling out in my little hand as we finish.
Thank you.
Thank you. Bye-bye.
All right. Goodbye.
Nah. All right, let's just listen.
1965, 1936. Two wrote 8 symphonies. Act 3 started in and he was
Hello? Hello? Hello?
Hello, can you hear me?
Yes, what is your name?
Sam Baydoun from Castle Auto Center.
All right, Mr. Baydoun, I'm gonna have to put you back in the waiting room because you are one of my two small claims appeals, and small claims appeals are done off the record. So I'll put you back in the waiting room, and when I get to your case call, I'll take you back out.
Yes, sir. Thank you.
Yes, sir. Back in the waiting room. Okay. Hello? Mr. Lakin, good morning.
Good morning.
I don't have your opponent as of yet.
Okay,
Back to the waiting room you go.
okay.
Oh, look, Carson. She is here. I've got her now, I think.
Yes.
All right, Mr. Lakin.
Good morning, Mark
Morning.
Lake.
I think I have both sides. We are on the record. Ms. Carson, turn your video back on. We are on the record with case number 2218039. Monique Carson versus Bobby's Towing. Date and time for pretrial. Your appearances, please.
Mark Lakin for Bobby's Towing,
Bar number.
P41147.
And your name, ma'am?
Monique Carson.
All right. My first question, Ms. Carson. It appears that you sent some correspondence to the court. Did you send copies of those pleadings to Mr. Lakin?
Yes. Yes.
It looks like an invoice from Bobby's TCB Service Incorporated, an estimate for service from a tire shop, and a retail installment contract. Did you get those documents, Mr. Lakin?
We did, yes.
Okay. Where are we on? Where'd she go? Where are we on this file? Is our written discovery completed?
Yes.
Mr. Lakin?
Yes, is she now, originally we were under the impression she was just trying to recover her costs of the tow and storage. Is she now claiming damages to the vehicle?
Yes.
Okay, that's a different claim. You're saying that, are you saying that Bobby's Towing did some damage?
Yes, when they pulled the car in the front, you had to put the 2 tire rods and the 2 tire arms on there. So I put that in there to show you that the car itself was taken and put on the back of a U-Haul and towed away. So that shows proof that when I showed the invoice that the police officer used Bobby's Towing to do a taking away of my vehicle, and it should not have happened. And that's what I was asking for, pain and suffering, because you took a brand new car from me. My brand new car, I just got it. And there's no reason that my car was supposed to be towed by Bob's Towing. They went behind, I don't know whose district, to do that against me. And that invoice shows the proof of it. That the police officer badge 2505 took and used Bob's Towing to hide my car.
Are you saying there was physical damage done to your car? Or not?
Yeah, the invoice.
I'm not asking whether the vehicle was towed. I'm asking whether you claim that there was some physical damage done to your car.
Yes.
What do you claim was done to your car?
The invoices that I showed you.
From the tire headquarters?
Yes.
All right. That's $1,268.14.
Yes.
All right. Okay. I'm going to give you guys one more period of written discovery, then I'm going to close it. We're not moving on the file here. We're not making any progress. We'll give you another date and get you on your way. The September 7th work for both of you at 11 o'clock?
Yes, it will work for me. But
Mr.
the
Lincoln?
discovery is the sheets of papers that I wrote and showed. So I don't know what under discovery there should be needed. I typed it out, I wrote it out, I wrote what happened to me, I gave the invoices, and everything's sitting with there. So I don't understand what else is in the discovery.
I'm working without a file right now, but I did review everything. I don't remember that you would have ever alleged that somehow the towing was done in a way that damaged your car. Do you have some sort of, outside of a bill of something, do you have some sort of letter or something that the towing or some person who's going to say that the tow damaged your car?
The whole purpose of this to suing Bobby's Towing is because you came and they stole my car. They
Right.
towed my car where there was no reason. I was not underneath my insurance. There's no reason why Bobby's Towing could take my keys out of my hand and with a push start thing and take my car, travel it to somewhere. This car is dated to banks. This car is dated to the Michigan Abandoned Registry. It was hidden. The fees, it shows you right there who did it. The invoice shows you. That's all the proof that shows you that this would happen to me. That is pain and suffering. As far as the discovery, I wrote it out the best I could. That shows y'all proof.
Your Honor, I appreciate.
Okay,
I
let's stop
appreciate.
right.
Yeah, and
Ms. Carson, I am looking at your complaint. Your complaint, let me go over it with you. You say illegally towing away the vehicle, number one.
Yes.
Number two, towing off a flatbed.
Yes.
Your Cadillac, take your keys. Number three, discrimination, violation of civil rights. Then it says number four, towing fees refunded back to me. Asking $25,000, pain and suffering, discrimination, violation of civil rights, financial hardship. You do not make a claim in your complaint, ma'am, that there is any physical damage done to the vehicle. Are you planning on making such a complaint?
That complaint goes with this.
Ma'am, excuse me. You're the plaintiff here. You can represent yourself. You have an absolute right to do that. You do not get your own set of rules. It is your obligation in the plaintiff, as a plaintiff, in your complaint, to set forth the claims that you have against the defendant, the damages that you claim the defendant has caused. In this complaint, you do not claim any physical damages to the car. So my question to you is, do you intend to claim physical damages to the car?
Yes.
All right, then, ma'am, I will give you both another period. I will allow you to file a first amended complaint. Because right now, you send in invoices, but you had not claimed in your complaint any physical damage to the car. You must file and serve your first amended complaint on Mr. Lakin within 14 days of today. I will see you people again September 7th at 11 o'clock. If you do not file that first amended complaint, we will not be in a position for you to claim damages that are not set forth in your complaint, ma'am.
Okay.
And let me just weigh in here that there's another possibility, and that's she could dismiss the claim, because two of her allegations are, number one, she's claiming damages in excess of $25,000. This court doesn't have jurisdiction over that matter. The second, a civil rights violation. The court has no jurisdiction over that matter. That's a federal claim. So perhaps Ms. Carson ought to think about dismissing this case and bringing it, whatever claim she has in the proper venue.
Well, that's a matter of motion for you, Mr. Lakin.
Yes, and I think we did ask to dismiss this case originally. I'm pretty sure that in our answer.
I filed a motion claiming that this court lacks subject matter jurisdiction here, sir. I looked through the file. You did not file such a motion.
All right. Just a suggestion, Ms. Carson, because that's coming, okay? If you file for that, I am going to file a motion to dismiss this case. It's going to waste a lot more time, in my opinion. Perhaps you should be represented also.
That's not correct. I have nothing but time. My car was stolen.
Okay.
That's what this is about.
We're not going to resolve it today.
Okay.
September 7th.
Oh, I have my first amendment.
And ma'am, you have 14 days to file your first amended complaint. Your written discovery will remain open. Thank you both for coming in.
Thank you. Well, I'm sorry, what was the new date?
September 7th, 11 o'clock.
11. Thank you.
All right. Thank you.
Bye-bye. you know?